Okay, get this. There's a rule from 1791, a time of horse-drawn carriages and powdered wigs, that's still being used to decide who gets a jury in, say, a billion-dollar tech lawsuit today. It sounds crazy, right? Well, that's the bizarre reality of the Seventh Amendment, and it's a constitutional puzzle that we're going to try to solve together. So let's make this real. Picture this. You're in federal court. Maybe your life's work is on the line, or you're fighting a massive injustice. You're suing for a sum that could change everything. Do you get to make your case to a jury of your peers? You would think the answer would be a simple yes or no, but it's not. It's not simple at all. And hey, don't just take my word for how messy this is. Supreme Court Justice Brennan, a Supreme Court justice, he once called the whole process a pointless rattling through dusty attics of ancient writs. I mean, when someone on the highest court in the land calls a part of the law pointless, you know we've got a serious problem on our hands. So here's the bottom line. Your right to a jury today doesn't depend on the facts of your case. It depends on this strange historical test. A judge literally has to play historian and try to figure out what an English court would have done back in the 18th century. It's a process that's confusing, it's inconsistent, and frankly, it's deeply flawed. And to really get why, we need a quick history lesson. Okay, so back in 1791, England's justice system was basically split right down the middle. It wasn't just one type of court. No, there were two parallel systems running at the same time, one called law and the other called equity. Understanding the difference between these two is the key that unlocks this entire constitutional puzzle. Let's break this down. On one side, you had the courts of law. Think of them as the rigid, by-the-book system. They followed strict rules, and their main solution for things was to award money damages. But most importantly, as you can see right there, they used juries. So what happened when those super rigid rules led to a really unfair result? Well, that's where equity came in. You can think of it as a kind of safety valve for the whole legal system. A judge, who was called a chancellor, could step in when the law just wasn't delivering justice. They were flexible. They could issue specific orders, like telling someone to stop doing something. And here's the crucial part. No jury, just a judge. And this is where it all comes together. The Seventh Amendment says the right to a jury trial is preserved in suits at common law. That's a direct quote, and it's a direct callback to those old English law courts. So the logic is, if your case would have landed in a law court back in 1791, you get a jury today. If it would have been in an equity court, you don't. Simple, right? Well, what happens when you try to apply that 18th century logic to a 21st century lawsuit? So how in the world does a modern judge figure out which 18th century court a lawsuit about, a software patent or a crypto scam belongs in? Well, they use a test that a lot of experts say is just completely broken. Here it is, the two-part test courts are supposed to use. First, they try to find a historical twin for the case from way back in 1791. Then, they look at what the person is asking for. Is it money, which is considered legal, or is it an injunction, which is equitable? But here's the really bizarre twist. Courts have just decided that step 2 is somehow more important. It's like comparing apples and oranges and then saying, well, the oranges are worth more points. It just doesn't make any sense. And you know what? Legal scholars have absolutely torn this test apart. One of the leading books on this whole subject calls it the imaginative construction of a legal culture that never existed. Let me say that again. A culture that never existed. In other words, judges are being forced to basically invent a history that isn't real, because the Old English courts just didn't think this way. So, to put it bluntly, the current test fails on pretty much every level. It's anachronistic. It forces modern ideas onto an old system that doesn't fit. It's incoherent. It weighs through things that can't really be compared. It's totally unpredictable, leading to all these bizarre and tortured results. And it's wildly impractical. It asks federal judges to become expert historians on 18th century English law. It's a total mess. Okay, so if the current system is so broken, what's the alternative? Well, thankfully, we're not just here to point out problems. Legal scholar Samuel Bray has proposed a brand new test, one that's a lot simpler, way more predictable, and ironically, actually more faithful to the real history. This new approach completely flips the script. It starts with a really powerful, clear default rule. In any civil case, we just assume you have a right to a jury. That's the starting point. This puts the thumb on the scale in favor of the jury, which totally aligns with the historical idea that the regular old courts of law were the main event. But that's just step one. That presumption in favor of a jury isn't absolute. It can be overcome, but only, and this is the key, only if the case falls into one of three very specific, very clear categories, and each one is an area that was historically the exclusive domain of those judge-only equity courts. So let's walk through these three exceptions real quick. First, you've got exclusive jurisdiction. Basically, if the entire area of law, like the law of trusts, for example, was literally invented by the equity courts, then nope, no jury. Second, equitable remedy. If you're asking a court to order an action, like an injunction, that part of the case is for a judge. And third, and you're going to want to remember this one, equitable aggregation. If the lawsuit uses a tool that equity invented to group a ton of cases together, no jury.
So what's the big takeaway here? This new test swaps out a messy case-by-case historical reenactment for a clear categorical analysis. It's just easier for judges, it leads to way more predictable results, and it's actually built on a more accurate understanding of how the old courts of equity worked in the first place.
Now, I know this might all sound like a pretty academic debate for law professors, but don't be fooled. Adopting this new test would have massive real-world consequences, and the biggest one of all might really surprise you. Remember that third exception we just talked about? Equitable aggregation, those tools equity invented to group cases together. Well, the most famous of those tools is one you have definitely heard of, and it is at the heart of some of the biggest, most high-stakes lawsuits in the entire country. That's right, zero. A big fat zero. Under this proposed new test, there would be no constitutional right to a jury trial in a federal class action lawsuit, period. It wouldn't matter if the plaintiffs were demanding billions of dollars in damages, the right would just vanish. So why? What's the historical logic behind this bombshell? Well, it's because the class action was born in the courts of equity. It was a tool a chancellor used to manage these massive, complex cases with tons of people involved, something the common law jury system was just never designed to handle. A class action simply was not a suit at common law in 1791, so there's no right to preserve. But there is one final, really crucial twist to this whole story. Everything we've been talking about applies to federal courts. The rules for state courts? That's a whole different ballgame.
And this raises a huge question. The Supreme Court could, in theory, force this Seventh Amendment rule onto all 50 states. It's a process called incorporation. If that happened, it would lock every single state into this 230-year-old legal framework. It could completely halt innovation and prevent states from designing their own, more modern justice systems that might work better. All right, so let's quickly recap the wild journey we've just been on. The current jury rule is a historical puzzle, a real mess. The Old English system had two tracks, law with juries, equity without. A proposed fix offers a much cleaner path. Assume there's a jury, unless one of three clear equity exceptions applies. The biggest bombshell from that? No more juries for class actions in federal court. And this whole debate shines a new light on whether state courts should be free to innovate or not. And that leaves us with one final fundamental question. The Constitution says the right to a jury shall be preserved. But what does that word really mean? Does it chain us to the legal world of 1791, forcing us to forever navigate all its arcane divisions? Or can we preserve the spirit of the jury right without being haunted by the ghosts of a system that vanished centuries ago? That right there, that is the multi-billion-dollar question at the very heart of this debate.